I think we can get started. Good afternoon, everyone. For those that don't know me, my name is Brian Gingold. I am the principal at IPV Litigation Services. We do multimedia litigation support, and my credentials for this presentation are I have a degree in film studies with a concentration in video production, and I've been in this industry doing sort of a fly on the wall for trials and depositions and things in the civil litigation arena for several years now. I've sat through tens of trials and hundreds of depositions, if not more. And so with that in mind, I put together this presentation called The Visual Verdict: The Critical Impact of Multimedia on Fact-Finding, Jury Retention, and Litigation Outcomes for both Plaintiff and Defense. What I've noticed sitting in on these trials and sitting in at these depositions is that, a lot of civil litigators, can kind of get lost in the weeds of these are the facts of my case and this is what I need to convey to a jury or what I need to convey to a witness. And they forget that there are different ways that human beings process information, and the best way to make sure that that information is retained and comprehended is to sort of blend different visual media technologies. So I want to just pose a question to you. It's going to be rhetorical, you don't have to answer, but how much of your last opening statement do you think that the jury actually remembered 48 hours later? So whether it was just a one-day trial or if it was a two-week trial, 48 hours after you gave the opening statement, how much of your opening statement do you feel was retained by the jury? Just kind of sit with that for a little bit. The visual verdict isn't about flashy technology. It's about aligning your advocacy with how the human brain is biologically wired to receive information. So this presentation, I've tried to make it sort of a roadmap to reduce cognitive friction for the jury. So the modern jury, you have to think in an era of shrinking attention spans, you need to capture their attention more quickly and more effectively. It's not just that the attention spans are shorter. Jurors are now almost all, if not fully, digital natives. They expect high-speed information delivery. When designing a trial presentation, you're not presenting to a monolithic group. Roughly 15 to 20% of the population are neurodivergent. That includes things like ADHD, autism. There's something colloquially called ADHD, that is both ADHD and autism. People that are dyslexic, people that have dyscalculia, people that have varying executive function capabilities and challenges. And I'm not saying you need to tailor your presentations for them, but if you're not at the very least considering that 15 to 20% of the population are neurodivergent, you're potentially missing out on communicating effectively with 15 to 20% of your jury. So how do people retain information? In 1992, there was a seminal study called the Weiss-McGrath report that set out to study what percentage of information was retained 72 hours after it was delivered. So when things were verbally told, it was only retained 10% of the time. When it was shown visually only, it was retained only 20% of the time. But when there was a combination of visual and verbal, it was retained over a 72-hour period, mind you, 65% of the time. That massive 45% jump in retention is when you are combining visuals with non-visuals. That's the difference between a jury that understands your theory and one that's just guessing at your theory. I also thought, though this was not specific to, the Weiss-McGrath report is not specific to civil litigators, I thought it was particularly interesting that 72 hours is kind of a critical window, because in my experience, that often windows the time between the opening statement and the start of deliberations. John, did you have a question? Oh, I'm sorry. I apologize. So as far as how our brains process information, the human brain processes visual information 600 to 600 times faster than text. I know that's a wide spectrum, 6 to 600. That again goes back to everyone has different brain processing. There are neurotypical, neurodivergent individuals, so it is a wide range. But with visuals, the brain doesn't have to translate an image the way that it does text or speech. So if I'm telling you about a hot air balloon, you have to imagine a hot air balloon. But if I'm showing you a hot air balloon, you can understand the mechanics of it or how the panels and patches are sewn together much better than if I'm just explaining it. That goes doubly so for individuals who might have difficulty processing imaginative information. While the speed is 600 times faster, the accuracy or the mental imprint is also higher because there's less room for the juror to misinterpret something that they think they understood but didn't, and obviously there's really no question and answer in the courtroom, so if they get the wrong idea, they're just going to run with that for the duration of the trial. Showing it and telling it is the best strategy. Speaking of, in the 1970s, I know the citation says 1991, but in the 1970s, Alan Pavio came up with a theory called dual coding theory. That was if you engage both channels, the verbal channel and the visual channel of someone's brain, they're going to process and retain that information better. The reason this citation is from 1991 is because when I discovered this source, it was somebody citing the dual coding theory in how they had used it to do just that and to determine how information is processed when it's both verbal and visual. So if you want to think about dual coding creating like a mental scaffold, so the visual creates the structure and then what you say fills in the structure. If you are a construction worker and you're just putting together slabs of drywall, it's not going to hold unless there's the scaffolding to give it its shape. The visuals give it its shape, and then the verbal is what fills everything in. And this is an example of where redundancy can be good. And I know that there's, obviously you guys are the experts when it comes to trials and civil litigating, but I've observed attorneys saying, like, you don't want to repeat the same thing 17 times. You're going to beat your juror over the head. They're going to get frustrated that you're not trusting their intelligence. And that's true. But to a certain degree, redundancy can be good. Saying what they are seeing in a non-monotone way reinforces the neural pathways, so you make the memory more sticky. So that would be like if I'm telling you about a hot air balloon, and then I show you an image of a hot air balloon, and then I show you a video of my client falling out of the hot air balloon, or whatever the case may be. Jurors today expect a high-tech presentation. This is called the CSI effect, and this has been studied. Actually, the citation that I picked is a judge sort of opining on, is the CSI effect real? And he concluded that yes, it was. So not that everything is a televised criminal procedural, but because of these televised criminal procedurals, modern juries expect a high-tech performance. If your presentation looks low-tech, jurors may assume that you don't value the case enough to invest in it. Now, I want to caution you, I'm not telling you to overproduce. You don't want to use, a 3D animation when a photograph would do, and you don't want to use, a video when a single sheet or a page of transcript will do. But you want to use multimedia to engage your juries because partly it's how their brains access and process the information, and partly it's an expectation of theirs. So what are these essential multimedia tools that I've kind of been alluding to this point? Obviously, there's way more than just these three categories, but I've grouped just sort of three main categories I want to talk about. You've got your impeachment video, that's your video deposition, your security footage, things that would either contradict or reinforce testimony. You've got your 3D demonstratives, that's your medical hardware, your 3D prints, your blown up photo aids, and you've got your interactive documents, callouts, highlights, and timelines that help make sense of really document-laden cases. Think about, I'm not trying to say that you should pick one strategy over the other where you should show a photo rather than showing a document. You want to think of it as a collaborative process. Everything is helping everything else. You just don't want to forget or forego the multimedia, the piece that engages the multimedia aspect. I sort of put it in almost like a hierarchy where you have what you say. There's no image on the screen, no document in front of the jury, it's just me talking to you. That is important. Next, you have things that are visually processed. You've got your photos, you've got your videos, you've got your blow-ups, things like that. And then the top tier is tactile. If you can put something in the jury's hands, they're going to remember it and process it much better than if there's just an image on the screen. So let me go into these a little bit deeper. So video depositions, transcripts do not do a good job, in my opinion, of conveying, and I hate this term, so I apologize, nonverbal leakage. That is the proper term for when our bodies betray us and say something other than what we are saying. So if I say in a deposition, no, I didn't do that, on the page it'll just say, no, I didn't do that. Whereas if my body language is shifty, and if I'm nervous, and if I'm sweating, and if I'm constantly looking to my attorney, that's going to convey something very different to the juror than just showing the page of transcript. A transcript might say pause, but a video shows a longer struggle. I have an anecdote I want to give. We made a settlement video for a case that is now over and settled, where an individual got hurt in a warehouse, and it was within his first month of work. He had not properly been shown all the safety procedures at this warehouse, and in the deposition of his direct supervisor, the question was, whose responsibility was it to train the plaintiff on these safety procedures? And on the page, he just answers the question. But on the video, he hems and haws for 45 seconds, and I'm not exaggerating. It was uncomfortable to sit through, and we made the decision in the settlement video to leave that entire 45 seconds in there, because that conveys something very, very different than just the answer on the page. Demonstrative evidence, things that you can actually show your clients. So for plaintiffs, day-in-the-life videos are a key piece of documentary evidence showing daily struggles. For the defense, these can be scrutinized against medical records, things like that. And expert authenticated 3D prints for medical facsimiles help put the jury inside the human body. So that is actually my skull and my brain from an MRI that I had. Non-medical MRI, I'm fine. But I participated in a medical study, and I got my MRI disc, and I printed my skull and my brain. And obviously this is not for legal purposes, but if that were to be authenticated against an expert report, it would be able to be introduced in court, and then you could actually pass that around to the jury. So if you think about putting a piece of failed medical hardware or anatomy in a juror's hands, or even for the defense, we have done 3D prints of floor plans where you could put that in the juror's hands and say, here's how the room was supposed to be built, here's how it was actually built, where's the issue here? It's very powerful, and that's why in my previous slide where I talked about first the audio, then the video, then the tactile is at the top tier. If you're able to make something tactile for the jury, they're going to remember it and process it much, much better than if they're just seeing it. For the defense, you have sub rosa investigation and social media mining, things that the most effective defense visuals show the claimed reality versus the actual reality. Another example from my personal life, I was recently deposed and in an auto case, and I was asked, if you weren't able at this period of time to sit in front of a desk for 8 hours, how could you hop on a plane and fly for 6 hours to Seattle? Because here's a picture of you in the Seattle airport. And the attorney thought that was a gotcha moment. There was an explanation for it, but that's neither here nor there. But these are important tools that you can use, and if you were to show that to a jury may say, why was he on a plane? So showing a timeline of happy photos can create sort of a narrative normalcy that could be difficult for a plaintiff to overcome. These are, again, just more on the defense strategies. Accident reconstruction-wise, reconstruction is about taking your expert's jargon and turning it into a first-person experience for the juror. I'm a big fan of, there's a colloquial term, gamification, and how if you can gamify things, it engages people better because you're making it interactive, you're allowing audience participation. And so if you make or have your animators or experts make a 3D animation that puts them either in a bird's eye view or in first person or third person so they could see something happening, that's going to, I think, sit with them much differently, not necessarily better, not necessarily worse, but much differently than if you have your expert up on the stand just talking about, how many microns this is supposed to be and how many meters away from the bush this thing was. And, that's important. I'm not here to say that that's not important, but you need to translate that into a way that the jury is going to understand, particularly juries that might have neurodiverse brains. So an animation allows you to show the accident or what happens from different perspectives. Like I said, bird's eye view, a pedestrian perspective, a participant's perspective. Medical illustrations, so photos of surgeries are often too bloody and confusing, and illustrations allow you to narrow the spotlight so that you're just focusing on whatever's important to your case, whether it's a surgery or something that went wrong. You're eliminating, if you show a photo of an actual surgery, even if it's permitted by the judge, a jury is going to get lost looking at the blood. They're going to get lost looking at, the seafoam green hospital gowns. You're going to want to show them, you're going to want to, like I said, narrow the spotlight on just what you want them to see. So that's where medical illustrations can be a powerful tool. Establishing causation, the best thing for that, for complex litigation, are timelines. So if the jury's first job is to understand what happened when, a visual timeline acts as their primary reference point for the duration of the trial. It's been my experience since I've been a fly on the wall at trials and depositions that timelines have sort of fallen out of fashion. I know that we used to use them a lot and have not seen them in many, many years. But when there's a case that hinges on a sequence of events, that's where your best friend is going to be a narrative timeline. And you can use color coding on your timeline, like red to suggest red flags or blue to suggest missed opportunities, to guide the jury's emotional response while still just presenting the basic facts. My personal favorite is the document callout, and there's a little looping animation on that screen in the courtroom that shows, when you put a multi-page document on the screen, the jury's going to start reading ahead. Not to steal Bianca's story, but as we were just kind of talking before the CLE, she said, if I'm reading ahead, certainly the jury's reading ahead, and I can't but help but to read ahead. So when you throw a document up on the screen, you can do a call out and just focus on the piece of information you want the jury to focus on. Call outs, highlights, these are going to be some of your best friends with when you're dealing with documents, and in particular document-laden cases. If you're just trusting the jury to follow along and stay with you on a full-page document, I don't think you're going to be successful. So as far as admissibility in Rule 403, so the purpose of the multimedia is to clarify the evidence, not confuse it. A court's main concern is going to be, will this help the jury, or is this just going to appeal to their emotions? Are they just trying to get a rise out of the jury? And again, that's where in the example of a surgery photo, you would want a medical illustration over a surgery photo to, I wouldn't even call it gore, but there's just a natural amount of unpleasant stuff in surgery photos that you wouldn't necessarily have to deal with in a medical illustration. Your visuals can't be inflammatory, as the slide says. A bloody or gratuitous animation or crop surveillance video could be excluded under Rule 403. So the main point of this presentation is I have sat through a ton of trials, I've sat through a ton of depositions, and what I've observed to be the most successful strategy is when you approach your trial as an opening, a teaching of the jury, and a closing. In your opening, you want to have maybe 5 slides highlighting your strongest pieces of evidence. Don't make the mistake of using every single piece of evidence in your opening. Just stick to, even if it's just your 2 strongest pieces, your 2 strongest visuals, or a visual to establish who your client is, and then a visual to establish this is a key part of what happened and a key part of the claim. Then in your teach moment, that's where you want to use a combination of, explaining your verbals to the jury, but also using documents, 3D demonstratives, document callouts, to explain the how and the why of your theory. Avoid an over-reliance on document data. And then for your closing, you want to re-show your greatest hits, just the 2 or 3 visuals that really landed during the trial. You really want to anchor their deliberations on your absolute strongest pieces of evidence. One thing that I would absolutely recommend and caution is I have seen what I call defeat being stolen from the jaws of victory from a case that should have been won because the jury's intelligence wasn't respected and people just kept hitting the juror over the head with every single point and every single piece of information. Trust that they're going to remember, but you just want to revisit your 2 or maximum 3 strongest pieces of information. So as far as case efficiency and outcome, many neurodivergent individuals struggle with something called working memory. So if I'm talking up here for 20 minutes without a visual anchor, you might lose the beginning of what I said by the time I reach the end. The constant visual scaffold, to go back to the contracting analogy, provides a persistent reference point that they can return to if they lose focus. If a juror has auditory processing issues, the visual anchor will help them focus and fill in the blanks and stay focused. Common mistakes to avoid: death by PowerPoint. That's putting every single piece of information on your slide deck. That's also reading directly from your slides. I've tried very hard in this presentation to augment the slides rather than just read them to you. You guys are all very intelligent, very capable individuals. You can read the slides. I'm just here to talk around the slides. You want to do the same thing in your presentations. Technical failures: not testing your equipment beforehand or not being adequately prepared. I'll give an anecdote of that too. We had a trial where we provided the trial tech and the opposing counsel was doing their own trial presentation, and they asked if they could use our trial tech, and of course we said sure, and they asked if they could practice during the lunch break. So they turned on our projector, they practiced what they had to practice, and then they left for lunch and they didn't turn off the projector. Well, the light from the projector was getting into the tip staff's eyes, and so the court officer, trying to be helpful, took a legal tablet and put it right up against the lens of the projector. And if you don't know how projectors work, that sounds like a good solution. But what that ended up doing is trapping all the heat from the lens, and it physically melted the lens of the projector and physically burned the legal tablet, and we got into a little bit of trouble with the court. That's since been resolved. I talked to Judge Hertzberg. It's all good. But there was, I know Diane Wainwright was concerned that we were going to burn down the courthouse. But we had to come up with a quick solution. Fortunately, we had a backup projector at the office. I had a runner bring it down to the courthouse, and we were back up and running in 15 minutes. But you have to plan for technical failures. And then overproduction. I've tried to talk about overproduction. You don't want to overproduce and overuse media. You want to use the right piece of media at the right time for the right application. So standard bulleted lists are a nightmare for dyslexic jurors and those with ADHD. The visual noise of too much text can cause the brain to just switch off. So using a high contrast call out and simple diagram allows these jurors to grasp the gestalt or the big picture of your case immediately without having to decode a giant wall of text. As I wrap out, my bottom line is the best technology is invisible. If the jury goes back to the deliberation room talking about your cool technology or your cool animation or your cool 3D printed demonstrative, your media has missed the mark. You want them going back to the deliberation room talking about the facts of the case and ideally supporting your facts of the case. Proper application of the proper technology is critical. These are some of the sources that I used for my presentation, and I'm very, very, very honored to be joined by three civil litigators, Bianca DiNardo from Goodrich & Geist, Rachel Meyer from Meyer-Dara, and Todd Hollis from Todd Hollis Law. And at this point, I want to turn it over to them so that they can talk about their experiences using multimedia at trial. So, Todd, would you like to go first?
Well, I always start from the notion that if a picture is worth 1,000 words, then the video should be worth 1,000,000. And you know, we try not to simply, you know, tell the story, but we try to show the story. And we want to do that from a real common sense standpoint, you know, where we can take the jury and put them in the shoes of our client. And, you know, I don't know how many of you know the Jim Rogers case that I tried. We brought that to a settlement. But, you know, the key component in that story was being able to remove all the doubts, all the possibilities, and to be able to show the city exactly what Mr. Rogers was going through just prior to his death. And we did that, you know, not just simply by using body cams, but, you know, we canvassed the neighborhood, we knocked on doors, you know, we took personal cell phone videos that the neighbors had taken. We also called 911, you know, we took the transmissions from the police officer to the operator, and the operator to the person that initially called. So we combined all of that in a video that showed the entire 1 hour and 6 minute transaction that led to Mr. Rogers' death. And then we were able to break it down, you know, into segment stories. For instance, we alleged that the city was responsible for deliberate indifference. So instead of showing the entire 1 hour and 6 minutes, we were able to take components of that video and say, this is where your officer or officers were deliberately indifferent. Excessive force. This is where your officer tased him. These were the facts. This is where he went into the gentleman's pocket without probable cause to do so. You know, this is why, you know, you're liable for excessive force. You know, and then, you know, we brought all of that raw human emotion, you know, into that video. You know, the people who were screaming, you know, Mr. Rogers who was screaming, you know, and essentially, you know, that human component is what led to the city saying, I don't want to take this chance and put this in front of a jury because this could be their uncle, their father, their brother. And we were very successful in that realm. And like Brian said, you know, you want to not make sure that you beat the jury over the head with facts, you know, at every turn, but you want to make sure that the jury appreciates that raw emotion that ultimately drives your damages, you know, to possibly change your client and or your client's, you know, lives. And we were successful in that realm. So to that end, that's my story. I'm sure these other lawyers have similar stories, but that's our story. If anybody has any questions, I'm happy to, you know, talk about it.
Awesome, Rachel.
Yes. So speaking of producing an emotional response, I practice civil defense. And so as the defense bar, we are often trying to preclude evidence that has that would produce an emotional response from the jury. And so a use of media at trial that I wanted to share was for a case that did end up settling the morning of trial. I can't recall whether it was before or after a jury had been selected. But the suit arose out of a single vehicle accident on the Pennsylvania Turnpike. And the plaintiffs were the estates of a husband and wife that were in the back seat of the vehicle that did die in the accident. Before I get into the details, I'd like to note first trigger warning, I would say, for the injuries that I will disclose in a moment here. And also, we were the only defendant remaining at this point. So the majority of liability had already been allocated amongst the primary defendants, and my client was a property owner, but there were still issues of both liability and damages for trial. So the accident, single vehicle, a man and a woman in the front seat, and then a man and a woman in the back seat. And driving in the right lane, lost control of the vehicle, crossed over left lane, hit the center median, and then crossed over both lanes of traffic and hit a guardrail. The guardrail had a rockfall fence connected to it, and the fence was held together with I-beams that were bolted to the guardrail. So when this vehicle struck the guardrail, it had flipped, the SUV had a sunroof in it, and the I-beam decapitated the man and the woman in the back seat. Obviously, the state police responded, and there were photos taken of the scene and the injuries. And prior to trial, the judge had already decided that those photos of the injuries from the scene would not be admissible. They were too prejudicial. They were graphic, gruesome images of these horrific and fatal injuries. I'm soft-spoken, I'm sorry. So yeah, the judge had already decided that those photos would not get in, and that the jury, by learning of the cause and manner of death as concluded by the medical examiner and common sense, would be able to fully comprehend the significant extent of these injuries. So the plaintiff's bar wanted to admit and show the jury sketches of the injury photos as drawn by an artist they had retained. And it was a very talented artist. The sketches were spot on from the photos. And the case did end up settling before even opening statements, so the judge never did rule on whether or not those sketches would be shown to the jury. But the plaintiff's bar wanted to have them blown up on a projector to show the jury, which would have had a profound impact on the jury's deliberations and ultimate decisions. So, on the defense side, we filed that motion in limine, really trying to preclude those sketches being shown to the jury. And so, like I said, it settled, so the judge never did rule on those. But the impact that media being shown to the jury can have is significant. And as he had mentioned, producing that emotional response from the jury, and as on the defense side, trying to preclude any evidence that would have that emotional response from the jury.
Rachel, thank you. Bianca?
Mine is not as heavy as that.
Sorry, everyone.
No. So I forget who told this to me, so I'm not going to take full credit for it, but someone had mentioned the one day that jurors, they're not just hearing cases anymore. They want to experience them. They're experiencing the trial with you as you're presenting it to them. So it is important to keep them engaged and active with what's going on, especially if you have things that will help them understand exactly what happened. Most times, if there's a car accident, maybe you're lucky and you have dash cam footage, but most times you don't have something like that. So whenever you do have that, you have to use it to your advantage. We have a case now, our client, we handled the summary appeal, and now we're hopefully going to be trying it in the fall. But it involved, there was surveillance footage of what happened. It's a case where someone was charged due to, there was an incident that occurred at a basketball game. It was against a coach. There was bickering between the coach, the ref. The ref never gave him a technical or anything like that, and then the school police officers got involved. So all of this was taking place inside of a school. So fortunately for us, there was camera footage from the gym. There was camera footage from the hallways. At one point, someone came out of an office. We have that footage of him coming out of the office. So when we were doing the summary appeal, we were in front of Judge O'Brien, and he sat there, and I mean, he had us stopping it, and obviously we don't always have that luxury with a jury of independently, oh, can you back that up, or can you rewind that, or fast forward it? But it was important for us to use that to our advantage to actually show that, you know, he was wrongfully charged for this, and that this should not have taken place at all. So in that situation with the video that we had, it was important because there were so many different angles of what was going on to actually line them up at the same time. I'm pretty good with my phone, but that kind of thing we did, actually Brian is helping us with that. But it was I think it's difficult to get everything lined up. But in order to prove our case, we had to show Judge O'Brien, and we will eventually have to show a jury, like what was happening because of how crucial it is to the actual cause of action. With that case, the summary appeal went in our favor, but it's going to be important for us in this case and every other case to make sure that the jury's actually engaged with what's going on. And because we have that video, it's more so not just telling them a story, but they're going to be actively involved with watching what actually happened. So just using that video instead of just saying, oh, this happened, and just like putting one up. We can simultaneously have all three playing. Or we can do one by one and show, okay, this is 5 seconds of this. Well, while this was happening, this was going on over here. So we're able to show the jury what exactly happened, and I think that is important to make sure that they have all of the information when they're actually going and deliberating and then ultimately coming back with a verdict. With that, I do think sometimes with we have different footage, like different angles, it kind of makes me think sometimes of whenever you're doing a video deposition that you're going to use at trial. I know some people want the transcript up, like at the same time. Other people don't necessarily want the words there. But I was actually just wondering how you normally handle that, because I know if I'm watching Netflix, for example, I like the closed captioning. It drives my dad crazy if there's words on the TV. So that's just something, I don't know, I thought of with like a jury, with how they handle that, if you're allowed to have the transcript of what's going on, because as you said, there's the breaks and things like that.
Right.
But so for some people it's easier.
For sure.
Understand.
So it's entirely up to our clients, but we do have the option that we can, with what's called a video sync, we could play the transcript with we could play the video with the transcript acting as closed captioning. And so you can have it sort of be a line at a time or 3 lines at a time, but you can usually play the video back with or without the closed captioning provided directly by the transcript. It's not like an AI trying to assume what's being said. It's the court reporter's words just playing either below or right alongside the video. To your point, Bianca, I didn't mention this in my presentation, but there is another admittedly very rare condition called aphantasia. That is the inability for the brain to conjure images. So in that example I gave during the presentation of if I were to describe a hot air balloon, someone with aphantasia would not be able to picture a hot air balloon. I'd have to put the photo up for them to understand what I'm talking about. So that just kind of goes to what Bianca, what you were saying about you want to engage your juries, make them feel like they're part of the process. Do any of you have stories where, whether it was you or opposing counsel, where it was either just your words, just the verbal, or just documents upon documents, and it maybe didn't have the desired effect of sticking with the jury in the right way?
I have an arbitration experience. It wasn't a jury trial, but I showed up at an arbitration hearing. It wasn't the case of the century, but I had a difficult time dealing with opposing counsel, and I was just trying to help a young lady out whose house had been flooded. We showed up at the ARB hearing. I had my trial pad. Opposing counsel had about 100, 200 pages of material that she sat on her desk. I presume she was intending to use it as exhibits at some point. But the problem is that, during the course of trial, as she was trying to look for the information, it became very difficult for her to find it. The 6 piles eventually became 5, 5 became 4, and before you realized it, she had, a slew of documents all over the table, and she couldn't figure out, what went where. But we had the videos, we had this, I had my iPad, I was able to bring the videos up, I was able to sync the deposition transcripts directly with, the video deposition of the deponent. I was able to go to key sections, during the course of the hearing, which she didn't have. And that had a huge, profound impact on the arbiters as they were listening to the testimony. So, I learned in that moment, you can talk all day, but, being able to actually show the story, being able to, find the information when you need it is compelling all day, every day. It doesn't matter whether it's a $20,000 case or a $20 million case. It's very, very powerful.
Rachel, do you have any experiences where you've seen either, the verbal only or just too many documents kind of lose track of where you are or where opposing counsel is?
My own humble experience, yes. The piles sounded familiar to me, early on in practicing. Luckily, it was in the setting of a discovery deposition versus, in front of a jury. But that was my own learning experience of how important it is to have your visuals organized and not in piles, and whether it's binders or for physical exhibits or media to be portrayed on a screen. So it definitely helps to make the argument appear more organized. It signals preparation and professionalism, rather than getting lost in piles and stacks of paper.
Bianca, do you have any experience with that, either firsthand or secondhand?
I can think of like one instance, also in a deposition. It was one of my first, I got admitted right before COVID, so a lot of the depositions were virtual at first, and this was my first one that was in person, like by myself, and I had way too many, it was a death case. She was a pedestrian, she was hit by a car, they were arguing liability. So we're deposing the defendant driver, and I used way too many pictures. Like, I just had way too much, and I was getting overwhelmed. So I knew that if we ended up having to try the case, that like I was significantly gonna have to cut down what I was using because I was overwhelmed during the deposition. I could tell the witness was overwhelmed. Everyone was overwhelmed. I think the court reporter was overwhelmed because we were marking so much stuff. So I think that was a good learning lesson for me, where it was just like I only had like pictures, but there were just so many pictures that were just, I needed to pick like the key ones, if that makes sense. So that was a good learning lesson, because if I did have to try that case, looking back to today, I know exactly which pictures I would have used, and it was probably a tenth of what I was using in that deposition. So.
And that can be hard. We made a settlement video for a client. It was actually that same case with the warehouse injury. And, he gave us the outline, we made the video, we showed it to him, and he said, this isn't quite what I want. He gave us a new outline, we made that video. In my opinion, the video was precisely what matched the outline. We presented it to him. He said, this still isn't what I want. Let me show you what I want. And then he proceeded to make a 1 hour and 35-minute PowerPoint presentation. And that's, we set it to, export as a video, where each slide was only on screen for 3 seconds. And it was an hour and a half. And we said, respectfully, your case inside and out. You've been working on it for years. You're going to lose, whether it's a mediator, an arbitration panel, or a jury, if you're trying to give them every granular detail. You need to whittle it down to just your strongest points. And we ultimately made, I think it was an 18-minute settlement video, and he said that helped the case settle. So it's down to kind of like, what Bianca was saying, and also the right application of the right media. You may have 40 great photographs, but you only need 3 of them. So you don't want to show all 40. Do you guys have any particular strategies as far as leading with your most powerful visual versus kind of holding it until the end of your case in chief? Or obviously every case is going to be different, but do you have any thoughts on, do you want to lead with your most powerful or finish out with your most powerful visuals? Todd?
I let the facts, I let the story, sort of guide me in how I do that. Juries will get lost. We had a jury in federal court, I want to say about 6 months ago, and we kept showing the same video. I mean, there were different aspects that we wanted the jury to see, but we kept showing the same video over and over and over and over and over again. And one lady, she, we spoke to her after the case was over. She was like, "Yo, we got it." Like, you guys didn't have to show us the same video like over and over and over again. But I think as lawyers, we're so detail oriented that we want to make sure that we check the box to say that we did that thing. But you can't underestimate the educational value of a common person. When they've seen it, they've seen it. And I think you just have to lead with your most important information, regardless of what that is, and then just kind of move on.
Rachel or Bianca, do you have any thoughts or experience on leading with your strongest versus letting the case dictate what you lead with?
Yeah, I mean, I think it goes on a case-by-case basis. In some cases you don't have that, really kind of game-changing evidence or significant few pieces. And so I think it goes by case-by-case basis. But I like the idea of mentioning it briefly during openings, and then it organically comes out during the trial, and then really honing in on it for the closing, right before the jury goes to deliberate. That's in their minds, and they to be able to circle it back if they still remember the opening statement to how it was introduced originally.
I agree. I think it's case by case basis, but I agree with Todd that you don't want to keep slamming them with the same thing over and over again and kind of questioning their intelligence, because even in a normal conversation, it's like, okay, you've told me this 17 times. I don't need you to keep telling me the same thing over and over again. I think it's important to lead with that solid piece of evidence or whatever it is that you have, move on, and then touch on it again in your closing. But I agree with Todd with what he said.
We have about 10 minutes left. I only have 1 or 2 more questions for the panel, and then I want to open it up to you guys to ask them any questions about, or me about your questions or experience with using different multimedia, whether it's at a deposition or at trial or for settlement. I'm really excited by this question. There's a specific psychological power in taking opposing counsel's own demonstrative and kind of repurposing it for your case. Can any of you tell me a time where the opposing side's visual has worked for your benefit?
So this is a case that I lost, but they had an investigator show our client getting out of his car, walking to a grocery store, and I think he was doing yard work and so forth and so on. And they tried to use that to say, you aren't as hurt as you claimed you were during the course of the deposition. We kind of leaned into it instead of backed away from it. We just simply said, well, he is a single person. He doesn't have anyone else to perform these functions. He's limping, and what else is he supposed to do? He has to eat. If he doesn't cut his grass, he gets fined. I don't think the jury ultimately bought it, but we did our very best to take what they offered and to use it to our advantage.
This reminds me of a case where We ended up having the plaintiff's deposition video recorded. And honestly, the only reason I had it recorded was because plaintiff's counsel insisted that my client's deposition would be video recorded. So I'm like, okay, same. Thank goodness, because this plaintiff, when testifying about her inability to lift up her arms due to her shoulder surgery, was lifting up her arms and talking about all of these things she couldn't do with her arms while doing the movement, like doing exactly what she said she couldn't do. And so the transcript, the way it translates in the video, just literally as she was saying it, in the transcript, the court reporter had tried to indicate the gesturing, but to have that on video of her and her shoulder injuries, and how they limit her ability to lift her arms as she is lifting and flailing her arms in the air. It's a great source to have in addition to the transcript and the gesturing text in the transcript as well.
Bianca?
We had a case where our client injured her foot. She fell down steps. It was a premises case. And during her deposition, we tell all of our clients, don't post anything to social media. Make sure just don't post. If you already did, don't delete it. We're very strict with them about not posting. She posted, and it was a picture of her at I forget exactly what it was. I'm not a big hiker, but it was somewhere where you go hiking. It was around Pittsburgh somewhere. And they pulled out the picture during her deposition, and they were like, is this not you hiking? And in my head, I was like, oh gosh, here we go. But then she was able to say, actually, yeah, and then she started going on about how she couldn't hike for a very long time. She had to get certain shoes. And so they, I think in their head, which I immediately thought it too, this is not great. Like, they're going to be able to say she wasn't able to hike or anything like that. And she was actually able to explain, which I knew that I had obviously talked about this before, but she really went into much more depth of how much more difficult it was. She had to spend more money to buy certain shoes. It was hard to go to her friends when they wanted to go. So that actually ended up working in our favor, even though initially it was kind of like, oh gosh, but that was one time where I can think of where it helped us instead of hurt us.
And mine is similar. In the deposition that I spoke about earlier, the gotcha moment was, well, here you are at the Seattle airport, but you couldn't sit at your desk for 6 hours, so how could you be on a plane for 6 hours? And say, well, I wore a neck pillow, I took Flexerol, and I was sore after the flight, but I wanted to visit my brother, and he paid for the trip, and I couldn't say no. So I don't think it landed as strongly for the other side as they had intended it to. So awesome. So we've got about 5 minutes left. I really want to open it up. Any questions for our panel or for me?
Yeah, Dave, you brought up a subject that I'd never really thought about before, was autistic or jurors that might, be dealing with ADHD. I guess the question is to everybody in the room, has anybody ever tried to ferret that out during jury selection, or is that too dangerous of a game?
I mean, as a layperson, I would just say I don't think it's worth trying to figure that out. I would just try to accommodate it and, make sure that your trial presentation accounts for different modes of memory retention and comprehension.
Next question, your brain, do you have a 3D printer? Is that where you?
Yes, yeah. So at our office, and this is not a sales pitch, but we do 3D print demonstratives. So
If you can ballpark, what would it cost to get your brain done?
We could talk after the fact. I don't. Yeah. Garrett.
It's like just a question on use of visuals, since it's all this presentation's about. So we talked about trying to get the jurors to be emotional and see things from the plaintiff's perspective, without violating the gold rule. And I just wanted to know if anybody on the panel, maybe you, Brian, have had instances in the past where, visuals like that have been used, whether to, success or detriment. And I mean like a point of view perspective from the plaintiff, trying to go about their daily tasks. Or maybe somebody who has visual disturbances from a concussion and they have, a point of view from somebody's eyes with visual disturbances, or somebody who has tinnitus to play the sound of tinnitus for the jury. Has that landed for you guys, or has that, been objected to as possibly violating the golden rule? Anybody up on the panel have any experience with that?
I'll say that the closest I got to that was just playing back day in the life footage at trial. And as I'm sure you guys all know, day in the life footage is silent, so there's no not even the sound of them grunting and struggling to get dressed and use the facilities. It's just a silent video of them going through their activities of daily living. We haven't done that first person, which is, I think, more of what you're asking. But yeah, I've not run into any issues with day in the life footage being considered prejudicial.
I haven't firsthand experienced it, but I was talking to my boss the other day, and he was telling me about one of the cases that he had, where he was able to actually have the doctor bring in like a rod and the plates that were used in the surgery, and they were able to pass it around the jury. So they were able to like feel like, okay, this is heavy and this is in their leg and that kind of thing. And he said that that was helpful. I mean, obviously there were probably motions about if they were allowed to do that or not, but he said that that was helpful for him.
To that point, I was doing the multimedia trial support for a trial where what was at issue was the acetabular cup that gets embedded in the hip for a hip replacement was like 2 or 3 millimeters too large for the hip socket, and when it was pounded in there, it fractured the hip. And so what my clients did is they passed around a model acetabular cup of the correct millimeter size and one that was the 3 millimeters too large, so that the jury could see them side by side. And they were actual medical devices. They were not reproductions. They hadn't been in anybody's bodies, but they were medical devices. Anyone else? We have time for maybe one more question. Yeah.
Here's one for you, Brian, or
Sure.
for anyone on the panel. Any visual device that was used that may have flopped, right? Kind of like used it and you see like didn't have the same impact that was expected with the jury or that sort of thing.
Sure. Trying to think. I don't have one that I could say outright flopped, but I will say one of the most peculiar circumstances I've ever had to do is we did a case where the expert, the medical expert, was from out of town, and he refused to work with digital x-ray films. He said, I will only work with physical films. So we had the x-ray films digitally, of course, from the medical provider. So we had to find someone to print them, and then we had to get a hold of an x-ray table. And then we brought the x-ray table into the courtroom, and then we hooked up like a downward-facing webcam, and then we had him manipulate the x-ray with his hands, and we showed that, we projected that to the jury live in the courtroom. I don't know if that was just because he was an older guy and he was kind of set in his ways, or if he thought that would land better than if he was, circling an x-ray on a digital tablet. I personally think it would have played better with sort of the more high-tech, lower footprint version of just having a digital x-ray. Anyone on the panel have experience with something that didn't quite land?
I saw the defense attempt to bring a witness in during the course of a trial, and they had not, I guess they hadn't used the technology before in advance of actually doing the trial, and they couldn't get whatever process they were using to work. So you had this panel of jurors sitting there waiting, trying to get this thing started. And ultimately, it worked, but they sat there for at least 15 minutes while opposing counsel fumbled through the process, and we just kind of milked all of that up. So, don't do something on game day that you haven't done in practice. I think that's what I took from that.
Rachel or Bianca? You don't have to, but if you have any experience with that, a visual that didn't land, whether yours or opposing counsel's, or a process or technique that didn't land.
I have one that landed better than even anticipated. Medical expert, he's an orthopedic surgeon, and talking about a screw being inserted into the bone of the patient and it being too long. And I wasn't even expecting him to do this, but it was a videotaped deposition for use at trial. And he actually took a screw, similar, the same one that would have been placed into the patient's bone, and he took it and he cut a piece of paper with it to show how sharp the bottom of that screw was, and to really emphasize, the effect that it had on the patient. But so, yeah, that one landed better than I thought when he cut that piece of paper with the bottom of that screw like it was nothing. We left that trial testimony feeling pretty good.
But Alice, I'm gonna think about that one, because I'm sure I've been witness to some visuals that didn't land, and I'm gonna think about that and get back to you. So we are at our time, so I just want to say thank you, everyone, for joining us. Again, I'm Brian Gingold with IPV Litigation Services. Here's my contact info, both my office and my personal cell. I invite anyone in the room to text, call, or email me at any time. Questions about the presentation, or if you want to do business, I'm happy to discuss that after the seminar. But thank you all very, very much, and thanks to Holly and the ACBA for facilitating this CLE. And thank you all for your time. And of course, thanks to the panel for their time and generosity as well.
Thank you very much.